They're going to win. They're going to win big. And a defeat in that building behind me, the Royal Courts of Justice, will cost Harry millions. Millions that he hasn't got. If Harry loses, which the Mail think he will, it will further damage his reputation. It will erode any remaining credibility that he may have, and it will clean him out financially, which, be clear, will place further pressure on that crumbling marriage.
Prince Harry walked into the Royal Courts of Justice believing he was going to win, not hoping, believing. He believed the evidence was on his side, that the Daily Mail had wronged him, and that a judge would look at everything and finally deliver the vindication he had been chasing for years. 11 weeks of proceedings later, the picture looks very different. The case is over. The evidence has been heard, and the people closest to this legal battle are now saying, quietly but clearly, that Harry is heading toward one of the most damaging defeats of his post-royal life. The judge, Mr. Justice Nicholson, is writing his reserved judgment right now, working through it in a full-time capacity over the Easter period. What he has to work with is a complex and at times chaotic evidentiary record that includes flirtatious Facebook messages directly contradicting Harry's sworn testimony, a key witness who repudiated his own statement entirely in open court, a royal editor who called the allegations against her a greater fiction than War and Peace, an argument between Harry and the judge himself, and a former editor of the Daily Mail who said the proceedings had, in the early hours of the morning, reduced him to rage. This is not what a winning case looks like, and the Daily Mail's legal team is reportedly confident of a favorable verdict. Not certain. Nothing in litigation is ever certain, but confident in a way that should alarm everyone in Harry's corner. To understand why this matters so deeply, you need to understand what Harry was trying to achieve and why so many people tried to stop him from doing it. The Convention Against Royals Suing Newspapers is not an arbitrary rule invented to protect the press. It exists because people who understand this world know that litigation exposes. It forces disclosure of information you would rather keep private. It subjects your own account to brutal scrutiny, and it produces outcomes that are genuinely uncertain no matter how strong you believe your case to be. Harry was told all of this. He proceeded regardless, and 11 weeks of proceedings have shown in considerable detail why the people who advised him against this were right. Let's start with Charlotte Griffith because this is where so much of the credibility damage originates. Harry told the court a clear story. He met Griffith once, discovered the next day that she was a journalist, had words with the friend who introduced them, and cut all contact immediately. That was his account, given under oath. Then the Facebook messages were disclosed. Those messages show a sustained, warm correspondence across multiple months, references to movie snuggles, a shared nickname she gave him, messages about shared social events, and at some point, Harry gave her his phone number. This is not the behavior of a man who discovered a woman was a journalist and severed contact immediately. The gap between those messages and the testimony Harry gave is the kind of gap that judges notice, and once they notice it, it shapes how they read everything else that witness has said. There is also a specific message referencing a dinner where Harry was making polite conversation with strangers while raising money for charity, cross-referenced against the court circular that appears to connect to a charity event Harry hosted at Clarence House in December 2011, placing them together socially well into the period when Harry claimed the relationship had ended. The documentary evidence tells a different story from the sworn testimony at almost every turn. Griffith's own evidence made things considerably worse for Harry. She told the court that during her social relationship with members of the royal family, she had learned that Princess Catherine was expecting her first child several days before St. James's Palace made the public announcement. She chose not to report it. She was sitting on one of the biggest royal scoops of the decade, and she left it on the table because she drew a clear line between her professional life and her private relationships. This testimony demonstrated genuine professional integrity and made Harry's characterization of her as someone whose journalist status made her fundamentally unsafe look increasingly implausible. Harry's legal team then suggested in closing submissions that Griffith had invented the pregnancy story entirely. That allegation, leveled against a respected journalist with decades of royal reporting behind her, may itself have caused additional damage if the judge finds it unfounded, which from what people close to the proceedings are saying, appears to be the more likely outcome. If you've never quite understood why everyone in the establishment tried to talk Harry out of this case, what has unfolded across these 11 weeks is your answer. Subscribe so you're here when the verdict drops, because what's coming next is going to be significant. But as damaging as Charlotte Griffith is to Harry's credibility, it may not be the most serious blow to his case. That distinction belongs to Gavin Burrows. Burrows was a private investigator presented by Harry's legal team as a key witness, someone whose evidence was intended to demonstrate that the Daily Mail had used unlawful methods, specifically private investigators, to obtain information about Harry. He was not a peripheral figure. He was structural to the case. His testimony was supposed to provide the documentary foundation for the most serious allegation Harry was making. And then Burrows appeared in proceedings and repudiated his own statement entirely. He said the statement attributed to him had nothing to do with him. He did not recognize it. He said you could tell from looking at it that the signature had been faked and traced. He said the entire case built around his alleged evidence was based on a pack of lies. He said he had only discovered his statement was being used in Harry's proceedings a year and a half later when he read about it in a newspaper. A key witness, called to provide the foundation for the central allegation in a major civil case, stood up in open court and said the evidence attributed to him was fabricated. If the judge concludes that a central piece of Harry's evidence was not genuine, the implications for his credibility as a claimant extend far beyond that single piece. Courts do not compartmentalize these things. A judge who has watched evidence collapse in this manner will examine the entire picture with that context firmly in mind. Harry's own presentation in the witness box did not help matters. He was emotionally charged throughout. There were moments approaching tears. There were moments of lost composure, where he crossed from answering questions into attempting to argue the case from the witness box. Mr. Justice Nicholson had to intervene explicitly, reminding Harry that witnesses answer questions rather than make submissions. He had to do this more than once. When a judge has to tell a witness to calm down, that observation becomes part of the overall assessment of that witness's reliability and credibility. It does not guarantee an adverse finding, but it does not help. Now, the legal framework matters here because understanding what the judge is actually deciding explains why these specific failures are so damaging. Harry's case is a misuse of private information claim, civil, not criminal, requiring the court to balance the right to privacy under Article 8 of the European Convention against the right to freedom of expression under Article 10. To win, Harry must establish two things: that the information was genuinely private and that the newspaper obtained it through unlawful means rather than legitimate journalistic methods. On the first question, he has some legitimate ground. Details of personal relationships and private movements are not automatically public property simply because the person involved is famous. But the second question, the unlawful means question, is where the case faces its most serious structural problems. And the Burrows situation strikes directly at the heart of it. The Daily Mail's alternative explanation is that the information came not from unlawful surveillance, but from Harry's own social circle. Friends who attended the same parties, moved in the same world, and chose at various points to share what they knew with journalists. Harry's own testimony acknowledged this anxiety, saying he had always suspected those closest to him of being sources. If the judge accepts that explanation, the claim fails entirely. There is nothing unlawful about a journalist receiving information from a willing source. Drop your thoughts in the comments. Do you think Harry walks away with anything from this? Or is it a clean sweep for the Daily Mail? I read every comment, and this question genuinely divides people who have followed it closely. Rebecca English, the Daily Mail's royal editor, directly addressed the specific allegations against her. She was accused of obtaining details about Harry's relationship with Chelsea Davy through illegitimate means, including allegedly monitoring Chelsea's conversations on a flight. English called the allegation deeply wrong and deeply offensive, something she would never consider, and noted there was no reply to the email presented as evidence, emphasizing she had never seen it. Paul Dacre, who edited the Daily Mail for 26 years, described the allegations in these proceedings as grave and sometimes preposterous. He said they had astonished and appalled him and reduced him to rage in the early hours of the morning. He was furious on behalf of his staff and on behalf of a newspaper he clearly believed was being accused of things that could not survive contact with the actual evidence. And here is the irony at the heart of everything Harry has done in this courtroom. He sued the Daily Mail on the basis that the newspaper invaded his privacy and commercialized his private life. His own memoir commercialized his private life to the tune of $20 million. His documentary series placed the most intimate details of his family relationships before a global Netflix audience. His interviews, his podcast, his public statements have constituted a sustained and very lucrative disclosure of private information about himself and everyone around him. The man claiming his private information was unlawfully exploited is the same man who sold his private information in the most commercially successful royal memoir in recent history. The judge is a human being. He is aware of the context, and those optics do not make Harry's position easier to defend regardless of what the formal legal analysis produces. The broader implications of a defeat here extend beyond Harry personally. The phone hacking scandal that brought down the news of the world and triggered the Leveson inquiry produced real changes in how the British press operates. Harry's case was positioned partly as a contribution to that ongoing accountability project. If the judge finds the evidence does not establish the unlawful methods alleged, that contribution will be the precise opposite of what was intended. A failed high-profile case that does not establish press wrongdoing after 11 weeks is a setback for accountability advocates and will be cited as such for years to come. The financial exposure is significant. In English litigation, the losing party generally pays a substantial portion of the winning party's costs. Associated newspapers will have incurred enormous costs across 11 weeks of trial. If Harry loses and is ordered to pay a substantial portion of those costs on top of his own legal expenditure, the financial impact will be severe. There has been speculation about whether meeting a cost order of that magnitude would require selling assets. What is clear is that defeat would compound a financial situation that is already considerably more precarious than the headline deal number suggests. There is one final dimension worth sitting with, and it is the human one. Harry went to court because he genuinely believes he was wronged. That belief is real. He grew up in an environment where the press was omnipresent and intrusive, where his private moments were subject to commercial interest he had no ability to control. His mother died in circumstances inextricably connected to the pursuit of public figures by the press. The anger that history generated in him has never left him. The desire to hold accountable the institutions he believes were responsible for his treatment is not contemptible, even if the specific legal choices made in pursuit of that goal were, on the evidence, unwise. What is genuinely tragic about this case is the gap between what Harry went to court to achieve and what the proceedings actually produced. He came for accountability. He came for a judicial acknowledgement of wrongdoing. What the proceedings produced instead is a public examination of his own credibility, his own private messages from 15 years ago, the reliability of evidence presented in his name, and his composure under pressure. He went to court to hold the press to account and found the proceedings holding him to account instead, not because the system is rigged against him, because this is what litigation does to everyone who enters it. The Convention Against Suing Newspapers exists precisely because this dynamic is entirely predictable, and the people who advised him understood it from the beginning. The verdict is coming. When it arrives, it will address each of the 14 pieces individually, assess credibility, and explain its reasoning. What it says about Harry as a witness, about the Charlotte Griffith messages, about the Gavin Burrows repudiation will be the most scrutinized part of a judgment the entire world will read. The dirty laundry has been washed in public. The messages have been read aloud in court. A key witness repudiated his own testimony. The judge had to intervene to calm a prince mid-testimony. And the case Harry was advised not to bring is almost done. The question of whether any of this was worth it will have its answer very soon. This channel will have the full breakdown the moment that judgment lands. So subscribe and turn on notifications so you don't miss it. Whatever the judge decides, the story of a prince who went to war with the press in a courtroom and found the courtroom a harder battlefield than he ever anticipated is one of the defining stories of this era. The final chapter is being written right now, and the world is watching.